"Dad, we need to talk about the house. You can't keep living out here alone. What if something happens?" That was my son-in-law speaking. Reasonable. Caring, even. That's what I thought at the time. I was 67 years old, a retired family court judge from Halifax, Nova Scotia, 31 years on the bench, and I genuinely believed my daughter and her husband were worried about me. I was wrong about that. I was wrong about a lot of things that winter. My name is not important. What matters is what happened to me and what I did about it. I'd been living alone in my house in Dartmouth since my wife passed 4 years earlier. It wasn't a grand house. 3 bedrooms, a double garage, a backyard that backed onto a creek. We'd bought it in 1989 for $127,000, which felt like the moon at the time, and it had appreciated considerably over the decades. My daughter knew that. Her husband, a man I'll call my son-in-law because I can barely bring myself to use his name, knew it even better. He worked in real estate. My daughter had been my whole world after her mother died. She drove out to Dartmouth on Sunday afternoons. We'd have tea, watch the game sometimes, talk about her kids. I had 2 grandchildren, 7 and 9, good kids who hadn't yet learned to see me as a number on a balance sheet. I thought my daughter and I were close. I thought what we had was real. Looking back now, I can see exactly when it changed. It was the autumn before everything fell apart. My son-in-law had been talking about investment properties, about how the Halifax market was shifting, about how certain assets were better held in family trusts rather than individual estates. I didn't think much of it. He talked about money the way some men talk about hockey, constantly and with great authority, and usually while reaching for another beer. But then my daughter started asking questions I'd never heard from her before. Did I have a will? Was it up to date? Had I spoken to a financial planner lately? She said she was asking because she loved me, because she wanted to make sure I was protected, because she'd seen what happened to other families when these things weren't sorted out in advance. All very reasonable, all very plausible, I answered honestly. Yes, I had a will. It left the house and my pension savings, roughly $840,000 combined, when you factored in the property value, split between her and my late son's estate, which was held in trust for his 2 children in British Columbia. My daughter knew this. She'd always known this. But something about how her face tightened when I reminded her about the BC portion told me she hadn't fully absorbed that detail before. The conversations shifted after that, subtle at first. My son-in-law started mentioning how expensive it was to maintain the Dartmouth property. My daughter started talking about how the stairs were a fall risk. Her husband brought a contractor over one Saturday, unprompted, who walked through and gave an estimate for accessibility modifications. I didn't ask for that visit. I never agreed to it. When I said so, my daughter laughed it off and said they were just trying to help. I started paying closer attention. In January, during the ice storm, the bad one, the one that knocked out power across HRM for 3 days, my daughter called and said I should come stay with them in Bedford. I agreed. I packed a bag and drove the 22 minutes to their house, and I was grateful for the warmth and the company and the noise of my grandchildren running around. I felt foolish for having been suspicious. On the second evening, after the kids were in bed, and my daughter had gone upstairs early with a headache, I sat in their kitchen reading and heard them talking in the room above me. The floors in their house were thin. I could hear clearly. What I heard made me sit very still for a very long time. My son-in-law was explaining something in the patient, quiet voice he used when he thought he was being clever. The property values in Dartmouth were peaking. The window wouldn't last. If they could get power of attorney before the spring market, they could list the house themselves, as his managers, acting on my behalf, and the commission alone would cover a significant debt they were carrying. The estate could be restructured afterward. My grandson in BC was a minor. Minors' trust interests could be contested. And then my daughter said something I will never entirely forgive, even now. She said, "He won't fight us. He's too tired. He trusts me too much." I drove home the next morning before they were awake. Told them I felt better and wanted to sleep in my own bed. My son-in-law offered to follow me in his car to make sure I got there safely. I said no thank you. I watched him in my rearview mirror as I pulled out of their driveway, standing in the cold in his socks, and I understood for the first time that I was looking at someone who had already decided I was an obstacle. I called my solicitor that afternoon, Margaret Chow, who had handled my wife's estate and whom I trusted completely. I told her what I'd heard. She listened without interrupting, which is one of the things I've always appreciated about Margaret. And when I was finished, she said, "Arthur, what do you want to do?" I said I wanted to protect myself, and I wanted to know exactly how far they were willing to go. What followed was 8 months of the most careful, methodical work I've done since I sat on the bench. I'd spent 3 decades watching people underestimate each other in courtrooms. I knew what evidence looked like. I knew what a case required, and I knew with a certainty I cannot fully explain that what I'd heard in that kitchen was not the beginning of their plan. It was somewhere in the middle. Margaret helped me restructure my will quietly. The house was placed in a living trust with conditions that made it legally impossible to sell without a specific and independent trustee, a colleague of Margaret's, a man in his 60s who had no connection to my family. I signed those documents in her Barrington Street office on a Tuesday in February, and I told no one. I also had a conversation with my family physician, a woman I'd known for 15 years. I explained that I was concerned someone might, at some point, attempt to have me declared cognitively incapacitated. She looked at me carefully and said that was an unusual concern. I said I'd spent 30 years watching families do unusual things for money. She agreed to document our regular appointments with particular attention to my cognition, my recall, my reasoning. She noted, in writing, that I scored in the superior range on every assessment she gave me. That documentation went into a file that Margaret held. My son-in-law came to visit me alone one afternoon in March. My daughter was at a school thing with the kids. He sat in my living room and talked for 45 minutes about estate planning, about the burden of property management in retirement, about a friend of his who was a notary and could help me review my existing documents. He was careful. He never said anything directly that could be used against him. But when he left, I went to my laptop and reviewed the footage from the cameras I'd installed in February. 2 small units covering the main living areas, positioned inside smoke detectors I'd replaced. Not hidden in a sinister sense. Present and recording in my own home. I watched him spend 4 minutes in my home office while I was in the kitchen making tea. I watched him photograph the framed document on my wall, my original bar admission certificate, and then opened the top drawer of my desk. He didn't take anything. He was looking at something. I pulled the desk contents that evening and found, tucked under a folder, a business card I hadn't put there. The notary, his friend presumably. I had it swabbed for fingerprints through a private firm that Margaret connected me to. The prints were his. April brought the conversation about power of attorney in earnest. My daughter sat with me at my kitchen table and laid it out gently. She was worried. I wasn't getting younger. The house required upkeep I might not be able to manage. What if I had a fall? What if my health changed suddenly? She'd spoken to a lawyer, she said, just to understand the options. And there was a simple process for granting her and her husband joint power of attorney over my financial and personal care decisions, just as a precaution, just so the family was protected. I asked her which lawyer she'd spoken to. She hesitated, named someone I didn't recognize. I said I'd think about it. I called the Law Society of Nova Scotia the next morning. The lawyer she'd named had been the subject of a professional conduct review 2 years earlier, involving a contested estate in Antigonish. He still had his license, but only barely. That same week, my son-in-law's business partner, a man I'd never met, who introduced himself as a financial consultant, called my mobile number. I don't know how he got it. He was friendly and professional, and wanted to talk about senior financial planning services he thought might benefit me. When I asked how he'd gotten my contact information, he said through a mutual connection, and when I pressed further, he said my family had mentioned me. I recorded the call. I kept the recording. I kept every recording, every photograph, every document, every timestamp. Margaret had by this point involved a colleague of hers who specialized in elder financial abuse cases. His name was Douglas. No, I can't use that. I've used him before in conversation. His name was Theodore Rains, and he was methodical and quiet and exactly the sort of person you want on your side when things get serious. He told me we had strong circumstantial evidence, but that we needed something more direct before we could involve the RCMP or Adult Protection Services. We needed them to actually do something. So I gave them the opportunity. In June, I told my daughter I'd spoken to a financial advisor and had decided to restructure the estate. I told her, carefully and with detail, that I was planning to sell the house privately, that a buyer had already expressed interest, and that I was considering consolidating everything into a single account that the family would have shared signing authority over. I watched her face while I said it. She was very controlled, my daughter. But her husband, who she'd brought along without telling me, leaned forward in his chair. He asked who the buyer was. I gave him a name and a number. Both belonged to a colleague of Theodore's, a retired RCMP officer who had done this kind of consultative work before. Professional, experienced, entirely in control of what he was doing. Over the following 3 weeks, my son-in-law called the number 4 times. He met the consultant twice, once at a Tim Hortons in Bedford, and once at a coffee shop in Dartmouth. Both meetings were recorded with full legal authorization. At the second meeting, he outlined a proposal. The house would be listed through his agency rather than sold privately. Documents my father-in-law believed were one thing could be structured as another, and the proceeds could be split in a way that would, quote, simplify the estate considerably. He said my daughter had some concerns about the BC beneficiaries and that there were legal ways to address those concerns if the will was restructured before my health changed. He used the phrase before his health changes, twice, as though it were a deadline he was managing. The consultant asked him directly, was I aware of what was being proposed? My son-in-law said that I was on board in principle, but that some of the details were being managed on his behalf. I was not on board. I had not been consulted, and those details were being managed against my interests, not on my behalf. Theodore filed a report with the Halifax Police Service and the Nova Scotia Office of the Public Trustee on a Thursday morning in late July. I sat in Margaret's office while he made the calls. My daughter and son-in-law were not aware of any of it until the following Monday, when 2 officers appeared at their home in Bedford with a warrant. I wasn't there for that part. I didn't need to be. What followed was 4 months of legal process. I won't pretend it wasn't difficult. My daughter hired a criminal defense lawyer, a competent woman who did her best with what she had. She argued that my son-in-law had only been exploring options, that no fraud had actually been committed, that the conversations with the consultant were speculative. The Crown's position was that conspiracy to commit fraud doesn't require the fraud to be completed. The recordings were clear. The documentary evidence was substantial. The fingerprints on the business card placed him in my desk. My daughter testified that she hadn't known the full extent of what her husband was planning. The court took some of that at face value. She was not charged criminally. Her husband was. He pleaded guilty in November to 1 count of attempted fraud over $5,000 and 1 count of breach of fiduciary duty in the context of an elder relationship, a designation that carries additional weight under Nova Scotia's Adult Protection Act. His sentencing was 3 months later. I attended the sentence. I sat in the second row, and I watched him stand before the judge. A woman I'd appeared before in a different capacity, years ago, and whom I respected, and listened as she read through the facts of what he'd done. He looked smaller than I remembered, less certain. The confidence had gone out of him somewhere in the months between the arrest and that morning. The judge sentenced him to 22 months in federal custody, suspended for the first 6 pending good behavior, with 3 years of supervised probation to follow. He was barred from acting in any financial capacity involving elderly individuals for a period of 10 years. His real estate license was referred to the Nova Scotia Real Estate Commission for review. My daughter was not in the courtroom that day. I walked out of the courthouse into a February afternoon, cold and clear, the harbor visible at the end of the street, and I stood for a moment just breathing. Margaret was beside me. Theodore had left after the verdict came down, as he always did. He was not a man who lingered for the aftermath. "You could have just changed your will," Margaret said. Not as a criticism. She was the one who'd helped me do exactly that 8 months ago. She was just observing. "I could have," I said. "But then they would have found another way. Another target. Another family." She nodded. We went for lunch at a place on Barrington Street I'd been going to for 20 years, and I had the fish chowder, and it was very good. My son-in-law and my daughter separated in January, before his sentencing. She came to see me in December, alone, without calling ahead, and stood on my front step in the cold. I let her in. I made tea. We sat at the same table where she'd laid out her case for power of attorney 8 months earlier, and we didn't talk about any of it directly. We talked about the grandchildren. We talked about her mother. She cried a little, and I let her, and I didn't say anything that I'll regret. She is my daughter. That doesn't change. What she did, what she was willing to let happen, that doesn't change either. We're finding our way back to something. It's slow. It may never be what it was, which is its own kind of grief. But I'm still in my house. The property sold in the spring, eventually on my terms, to a couple from Ontario relocating for work. I got $1.1 million for it. I bought a smaller place in Chester on the South Shore, half an hour from Mahone Bay. 2 bedrooms, a wood stove, a decent view of the water through the trees. It cost $485,000. The rest went into a combination of registered accounts and a fund I set up through the Nova Scotia Community Foundation, directed at legal aid services for seniors facing financial exploitation. I have 2 grandchildren who visit me on alternating weekends now, which their mother arranges very carefully and correctly, and which I appreciate more than I know how to say. We go down to the water. We play cards. The older one has started asking me to teach her chess. I told her the most important thing about chess isn't how to win. It's how to see what your opponent is planning before they know you've seen it. She thought about that for a moment, the way kids do, seriously, with her whole face. Then she said, "Is that why you always win, Grandpa?" I told her I'd been practicing for a long time. I drove home that evening along the 103, the bay visible in the last light of the afternoon, and I thought about a lot of things. About my wife, who would have handled all of it better than I did, and with more grace. About my son-in-law's face in that Tim Hortons parking lot, confident and careful, already counting money that wasn't his. About my daughter saying, "I trust him too much, he's too tired, he won't fight." I spent 31 years watching people underestimate each other in courtrooms. I watched clever people lose because they forgot one simple thing. The person across the table has been alive just as long as you have. They've learned things you haven't imagined yet. And the ones who look tired are sometimes the ones who've already made every move they need to make. I'm 68 now. I wake up early. I walk down to the water most mornings when the weather allows it. I make good coffee. I read. I play chess online in the evenings against people I'll never meet, in places I'll never go, and I win more often than I lose. That's enough. That's more than enough.